let's move on to the graffiti ordinance. So it's going to come back with some language changes and then after the rest of the and we're moving on to the graffiti. Okay. Great. Kim, can you start with, and I think that they're actually, we can certainly say what the lawsuit is, what the claims of the lawsuit are for the public, right? So that there's an understanding and also maybe an understanding.
There's not currently a pending lawsuit.
There wasn't a lawsuit.
Oh, really? I thought that we got a note from Jared Carter, which I thought said that he was suing on behalf. No?
No lawsuit was filed.
Oh, just okay. So clarify what it is, because even I apparently misunderstood.
Well, there were tickets issued for some stinkering, and those tickets have since been dismissed. There was also a letter that we received regarding concerns over that, but there's been no lawsuit filed.
Can we share what the concerns were in that letter?
I don't have it, but Eric, do you? Eric. Yeah, I mean, I don't know that we should get deeply into it since.
I mean, it would require us to share until impressions. Theories that are out there about accepting this issue. We can do it.
I don't know if you have an opinion on this, Gene, but I'd like to share publicly just the basic premise about how that came to be and why they felt it was enforced unfairly.
I'm not sure at this point that I'd be looking to have a public explanation of confidential attorney-client communications and the attorney product.
No, I don't want that. I want to share the letter not that we got from our attorneys. I want to share the information that we got from the opposing attorney.
It would be, I'm sorry for interrupting you, Chair, but it would be difficult for me to have a clear communication with you about that without also revealing my mental impressions. It's very difficult for me to walk around doing that.
Okay, it may be worth us having an executive session around and getting some legal advice on this matter. I know we have a member of the public here who's specifically concerned with this. So interested in thoughts on whether we start with an executive session for a finite period of time, maybe 10 to 15 minutes, and then go into public session, or if the committee would prefer to move forward with this in public session. I mean, we have the benefit of knowing what was communicated to us by the attorney from the person who was ticketed. I actually don't recall that we've had the benefit of hearing our city attorney's opinion of that letter. So, which does have some bearing on how we go here, or maybe it doesn't. Thoughts?
I mean, the proposed changes, they speak for themselves, and we should be able to get opinions about their constitutionality and what they are attempting to do. I'm looking at, in particular, the electronic advertisement, what have you, provision. It's E. that's being added to the graffiti ordinance. As you know, to the extent to which this, we need to hear from the attorneys in executive session about the allegations or the concerns related to the prior enforcement actions. Then I think we want to do that. I'm not clear though that we want to do that in executive session, but I'm not clear that they can't be separated. I do think it would be helpful for us in the context of looking at the graffiti ordinance generally to see about improving it, to hear from the attorneys in executive session about the legal issues that involve the prior enforcement action.
Thinking about that, actually, I don't think that there was even any claim that there was anything wrong with our ordinance in that case. There's no claim that, and we're only talking about the ordinance. We're not.
I am going to recommend we go into executive session if that's okay. Sure. And if you need help with the ordinance, I can.
Okay.
Or with a motion cover.
Let's just take 10 minutes, if that's okay with the committee, to go into executive session, so we waste no more time arguing about it.
Yeah, no, let me just be clear. I've got to leave because I have an appointment at 2 that I have to travel.
Our plan is to be done at 1.
That's what I'd like to hear.
Yeah,
right?
We're going to be done at 1.
But yes, I know that our agenda is long, so good. There you go. I'm good with you going into executive.
So the first motion I would need a first and a second for is to find that premature public knowledge of attorney-client communications would clearly place the city at a substantial disadvantage because the city was disclosing said communications.
Could you repeat that last part a little more clearly?
The city risks disclosing confidential attorney-client communications on attorney work product.
I would make that motion.
Second. Any discussion? All those in favor, please say aye. Aye.
The second motion is to find, based upon your previous motion, your previous finding, or to move rather, that the city enter into executive session to communicate with counsel pursuant to 1 BSA 313A1F to include legal counsel and the members of the committee.
I would make that motion as well.
Second. Any discussion? All those in favor, please say aye.
Aye.
Aye. And with that, we will go into executive session, and we will come out of executive session at 12:40. Okay.
And Chair, just to state who is staying in executive session.
It's just the members of the committee and our 2 city attorneys.
Thank you.
Hey, everybody hung in there. That's great.
Yeah, Joe is.
Yes, I've asked the city attorney to make a statement about what we can tell you about how we got here. So go ahead.
Yeah. So the intent of what I'm bringing to you today is not to respond to anything that a government is holding in violation case that we talked about right before we went into closed session or executive session. The intent of this came about long before that, and was just raised because there was a desire among the city's elected officials to see if we could do more to protect members of the community, do more in our ordinance code to protect members of the community from intimidation or harassment on the basis of particular classifications. And so I want to make that clear. I also want to sort of explain how what I presented to you today differs from what you looked at the last time. The last time we talked, we were speaking in the context of graffiti, and we talked about the fact that the courts have decided that if something is already illegal, if it's done with a malicious intent to intimidate and harass somebody on the basis of a protected classification, that can be enhanced penalties for that thing that's already illegal. And what I brought to you last time was the attempting to insert language into the graffiti ordinance similar to language that's been upheld by other courts throughout the country regarding the issue of graffiti. The enhancement. So.
Oh, I can get it for now. Sorry.
The enhancement that was inserted into that draft language last time is the enhancement that's built into Section 1 of our city code. We have substantially similar penalties for offenses under the ordinance code that are considered criminal or civil, but one gets prosecuted in the Judicial Bureau and doesn't carry with it criminal sanctions. So that's sort of the natural enhancement that's built in. And the committee raised the concern, if we enhance something that's a civil offense and call it criminal, are we criminalizing, potentially I'm going to be accused of criminalizing speech? The case law doesn't deal with that because all the cases around this deal with graffiti ordinances or statutes that are criminal in nature. So this could be kind of an issue of first impression. I think the point was well made. I think based on that conversation, we probably want to keep things simple. And so I was trying to look at what can we do under the ordinance code as it exists, and what can we do under Vermont law that deals with quote unquote hate offenses differently than a normal civil offense under section of so as it stands now. And it occurred to me, a couple of things occurred to me. One is that Vermont law gives us as a city the power to define what constitutes a public nuisance and to determine how to enforce and abate that nuisance. The other thing is that the definition of a public nuisance is something that's sort of interferes with the health, safety, and welfare of others that affects the public at large. Why do the courts allow us to have enhanced sentences for things done with a hateful motive? They say we're allowed to do that because if you do something that's otherwise illegal with a hateful motive, you're damaging the community as a whole rather than just the individual victim. And it makes everybody more afraid, less secure. And so it strikes me that we can make a very good argument that, and since we have the ability to define this under Vermont law, that doing anything that otherwise violates the ordinance code with this malicious intent to intimidate or harass somebody on the basis of a protected classification is in effect a public nuisance, and we can define it as such, and then that gives the city or anyone uniquely affected thereby the ability to bring a civil action to stop the conduct and to request attorney's fees if they prevail. So that's the proposed change, and I would make this in 1.9, and I would take this outside of just the context of graffiti that the conversation originally started, because anything can be done with such an intention. That's the first change that's proposed here. And the second change deals specifically with graffiti. Another takeaway I had from our last conversation is that a problem we have with graffiti in the cities, we just don't have the capacity in general to enforce our ordinance. And so I'm proposing that we add something here to the ordinance that, in connection with our last conversation, technically could be done through policy. It doesn't actually have to be in the ordinance. But we could set up a system where people can electronically report graffiti. And we have this see it, fix it, click it, I always say that wrong system. But I'm not really proposing that we use that because that's public. And we don't. I think in order for this to be effective, an effective tool for the police to actually use to enforce any graffiti violation of any kind, it would be better if people could report to the police and not public commenting on it.
Yeah, that's a good point.
So
if see-click fix could just turn off that, is that a feature?
I don't know, but to the best of my understanding, it has to be that way. So I would, maybe just have an email, dedicated email address or something. And then if the police are receiving evidence from the public about where graffiti is and who's doing it, they might be very able to enforce regardless of the type of graffiti. So those are the two changes I'm bringing to you this time to deal with those issues in the conversation we had last time. But versus telegraph.
Right. With Kim gone, do we lose our ability to put the ordinance up on the screen?
Not as good with technology as she is, but I will try.
Be careful, you might share something on Kim's computer.
Yes, I better wait.
Okay, so comments from the committee?
So, in terms of the enhancement, it appears to me that we are not declaring that such a public nuisance is subject to any individual fine or criminal penalty. The only enforcement that you've got is injunctive, is the seeking of injunctive relief, and then the extent to which the costs associated with bringing such an injunctive relief would get played into that. And this is both for the city, but also you opened up for a private right of action.
Right.
Can you clarify what you
speaking
just?
English.
Yes, I'd appreciate it.
Not
Right.
very
That's
clear.
sweet.
You understood what I said.
The rest of us, Gene,
Before he translates, could I add one point to that? Yeah.
in English.
Maybe not. Whatever way you want, then we'll translate.
Yeah, Gene can be my translator.
That's right.
That's right. I just want to make clear that we're not taking, in order for this to fit within this definition of public nuisance, something would already have to be an offense under the ordinance.
Yes.
So there would still be the existing criminal and or civil ticketing enforcement. This would be in addition to.
Just to be clear, because I'm not reading as you would have to bring a separate ticket, although it would be helpful in terms of the proofs. But you would have to prove that it was a violation. So you could decide that you were going to forego the judicial bureau. You could go to the Superior Court across our street here, Kitty Corner, and just have to prove it's a violation of the noise ordinance. And we do that in sort of the same way we do tickets. And then on top of it, we then also have to prove the intent here, right? But we would not have to have issued a noise ticket.
We would not have to have done that. We could do.
Exactly.
So you're saying
So
you
with
get
the-
a noise order.
So this, it might, let me see if I can, on the fly, without thought, translate this into plain English. We have the right to declare things public nuisances because they interfere with people's right to enjoy life, liberty, and the pursuit of happiness. And so we can go into court and say to the court, judge, tell them to stop. And what this does here is it says that not only is there this sort of general thought about public nuisance, and that's what's on number one, is not being changed. But if you're going to do something that's in violation of the ordinances, right? So it's a civil or a criminal offense, because we have criminal offenses still. And you did it because you wanted to intimidate them or harass them. And that was because that particular person or that group fits within a protected category, and you've got the list. Then we are, by this change, going to allow the city, but also a private person, to petition the court. Civil, it would be a civil case, to say stop. And not only stop it, but because you made me have to come in here to stop you from doing that, I want the court to order that you pay my attorney and that you pay all the court costs that were associated and that are allowed under the statutes to do that. So this is, there's no separate fine that's associated with this violation, but it is a declared by this change to be a specific public nuisance, and it would carry over not just to graffiti, but to any violation of our ordinances. And the big one that makes sense to me easiest is the noise ordinance, and that could be, to put a really gross thing, I could have my favorite neo-Nazi who sends me all sorts of stuff very periodically, and you could come, and I'm not encouraging you this, please, to come across the street from my house at midnight and blare on a loudspeaker, "I'm a dirty Jew," and really loud, right? That's, and like, go home, wherever. And that would fit under my religion or national origin or ancestry. The definition, and it would be a violation of the noise ordinance, and clearly they'd be directing it towards me, and I think the facts would show it's malicious, an attempt to harass me at the very least, if not intimidate me. So you can get a bunch of facts and add to the thing. And I could, under this proposal, I could take that person to court. Tell them, shut up.
Okay. Yeah, go ahead.
I get that right? Yeah, pretty good.
Is that only because there was a protected class, or would you have the right? So if I'm a business owner and somebody keeps tagging the side of my building, and I figure out who's doing it, police won't arrest them for whatever reason, and I identify them with their name, does this change now allow me to take them to court because they're individually targeting me as a business by putting graffiti on the side of my building?
I personally, and I'll leave this to the lawyers, but I do not see landlords as being part of the protected class.
No, I'm not talking about a landlord, I'm talking about,
Business owner.
yeah,
I don't see.
so it's only the protected class that.
Well, you can look at the list. I mean, the list sort of, if you fit into that list, or you reasonably have a way to fit into the list, then I think that you fit into the list, and where you're really shoehorning yourself into the list, that will then maybe make it more problematic.
Yeah.
Can you put this up on the screen?
So if I could add to that, I mean, this list of protected classifications, these are protected classifications of the law. So that's why I posed this list. That said, I mean, if somebody is tagging your individual business and damaging your property, you already have a private right of action. This is just creating
Okay, you already do.
public right of action that we're doing something that might not already create a private right of action, but that affects the public's right to feel safe.
Okay, so I wanted to run through some scenarios to better understand this, and going also to what Todd said at the beginning of this. So if you say all fascists, if you have graffiti that says all fascists die, fascists are a political group, and whether it says all fascists die or all progressives die or all whatever political group die, they're going to be treated to the same under the law, no matter how we feel about that particular political group. Are we okay with that kind of threatening language to any group outside of the protected classes? So the protected classes, how? I'm going to replace the words "all fascists die" because I think that there is a broad sentiment of dislike towards fascists, and I'm going to replace that with another unprotected class, all Green Party activists die. Okay. Versus a member of a protected class die, all service members die. Under this law, in both cases, it's threatening a class of people. In one case, it's threatening a protected class of people. So what happens based purely on the threatening aspect of this language?
Yeah, so I guess I'll try to answer that question. One is that, certainly we could add to this list political belief, that is the protected classifications, jurisdictions laws. The other thing is that we could have enhanced penalties for anything that's a violation of the ordinance code that's malicious, intimidating, harassing. Period. It has to already be illegal. We can't just, make. You can't have a law that says no intimidating and harassing speech. You have to rise to the level of inciting. But if something's already illegal, you can have an enhanced sentence because the person because of their motivation is hurtful. I wouldn't recommend, if this is the approach that we like, I wouldn't recommend having it here that anything that's intimidating and harassing can be enjoined this way, because now we're sort of taking it outside of the public use of public nuisance. In order for something to be a public nuisance, it has to harm or inconvenience the public at large. And the courts have said that if somebody targets somebody because they're a member of some protected class, that hurts the community as a whole.
Well, I think it goes a little bit to what Becca was saying, the reference that Becca gave. You said that there's other, that you already have a private right of action. If as a business owner, you're being perpetually targeted, you have a private right of action. And the difference is that a member of the public can't step in and say, I have been impacted by the fact that this business has been repeatedly attacked with graffiti. The business has the right to say that, not a member of the public. So these classes give members of the public a right to take action that doesn't exist when somebody is personally targeting me. I have my own private right to take action.
Right, yeah, good point. So if somebody were posting stickers about you personally and threatening you personally, and you felt threatened by that, you could go seek a relief of abuse order. The focus here is on the interest of the public at large. How somebody's conduct threatens the public, a larger segment of the public.
Okay. So all of that threatening speech, we have the ability to act on it through private actions. The city doesn't have the ability to act on behalf of that property owner that is repeatedly getting tagged. That property owner has the ability to act. But if that property owner is being tagged with something that is regarded as hate speech and hurtful to the community, then the city has the right to act upon that. Is that correct?
Right. That's the basic idea.
Okay.
There's no meeting for that one.
Good one. Oh. Boy, God, I was staying on time. And it's 1:00 now, so apparently we're all turning into pumpkins. But Jean has to leave, and I do want to stick to our time limits despite my inability to. I'm not ready. I want to understand this other scenarios a little bit better than I do right now. So I think we'll have to set up a meeting by doodle poll. Maybe we can send you questions that we have about this to be answered. And we'll send you those questions privately, and you can send us all, to avoid public meeting law violations. Send your answers to the committee, and the committee will not respond to any of that except one-on-one with the attorney's office. Okay?
Sure.